Hi there, welcome to our seminar or webinar, I should say, today on data subject access requests. So for those who joined us yesterday for our case law update, you'll know that I'm Mark Clayton. I'm joined again by my colleague Joe Hale. We're both employment lawyers in the team. We've also got Thomas Bennett with us today, who's our expert production assistant, who's hopefully going to make sure that all the technology runs smoothly. So thanks in advance, Thomas. So today we're going to talk about responding to data subject access requests. We're going to look at questions such as what amounts to a DSAR, when can we refuse to respond, how extensive does the search need to be, disclosing information about other people, some of the information that does and doesn't need to be disclosed, so looking at some of the exemptions, and also looking at the penalties for breaching the legislation. Now, we've decided just to focus on some of the questions that we get asked most frequently, rather than giving a comprehensive overview of the sort of DSAR regime, which wouldn't be possible in the time that we've got. And the reason we've decided to focus on DSARs is because we're seeing more and more requests. They're often used as a tool in litigation to try and get early disclosure of information. And data protection and processing data has become a bigger part of our lives as we become more and more digital. So we thought it'd be a good topic to talk about. So without further ado, I'll move on to the first slide. So what amounts to a DSAR, data subject access request? Well, an employee has the right to obtain from their employer information about whether or not they are processing their personal data, and if so, they have the right to access that data. And that's been part of data protection legislation since around 1984, so quite some time. The request can be made by any means, so it could be email, in a letter, it could even be by social media, or it could be made verbally. It can be made to any person in the organisation, whether that be a manager or director or someone else. And it can be in any format, so it doesn't need to be on a standard form. It could be just in a simple email, and it also doesn't need to say that it's a DSAR. It could just be someone saying, please provide me with all the information you have about me. So it's really important that you train employees to recognise a DSAR and also train them on what to do if they get one, so who in the organisation they should refer it to. It's important to remember as well that in most situations you can't charge any fee for dealing with a DSAR now, which is different from the old regime. The other point I suppose I would make is it is probably still worthwhile having a policy setting out who you would prefer people to make a DSAR to try and ensure that they're routed to the right place. And also having perhaps a standard form, because that way you can ensure that you're more likely to get useful information about what types of data the individual wants, and that may help you to narrow the request. It's just important to remember though that if people don't follow that process, you still probably have to deal with the DSAR. So moving on to the next slide now. We'll look at when you can refuse to respond to a DSAR. So there are really two situations. Firstly, where a request is manifestly unfounded, and secondly, where a request is manifestly excessive. And in those types of situations, you can either charge a reasonable fee for dealing with the request, or refuse to act on it altogether. Now, the onus will be on you as the employer to prove that it's manifestly unfounded or excessive. So you want to be careful about relying on these reasons, and don't be too cavalier in asserting that it is. So if we just move on now to talk about what manifestly unfounded means. So the Information Commissioner has provided some useful guidance here, and really it's about focusing on the intention of the individual making the request. Where the individual has no intention of exercising their rights of access, where, for example, there's a malicious intent, or it's used solely to harass or cause disruption to the organisation, then it may be a manifestly unfounded request. And the factors that the ICO provide to indicate whether a request may have a malicious intent are as follows. They suggest that it might be manifestly unfounded and have malicious intent if the individual states that their intention is to cause disruption. I have seen requests before where an individual has stated that. They've stated, you know, I'm making this request because I know it's going to cause disruption, and they've offered to withdraw the request in exchange for a settlement offer, for example. That would be a good indication that there is a malicious intent. Where the request makes unsubstantiated accusations about the organisation or about a particular employee, that would also indicate some malice behind the request. Or where the individual systematically sends different requests as part of a campaign in order to cause disruption to the business. So, for example, if they were sending one request per week, that might be a factor indicating their malicious intent. It's important to remember that just because an employee made a previous request that was manifestly unfounded, that doesn't mean that this one is. So you have to look at each request on its facts. And the Information Commissioner says it's not a tick box exercise. So you have to look at the context in which the request is made. If the individual genuinely wants to access their data, the likelihood is that it's not going to be a manifestly unfounded request. Just look on the next slide. There is an example from the Information Commissioner of when a request may be manifestly unfounded. I won't read it because you've just got it on the slide if you want to have a quick look. Now, on the next slide, we'll look at when a request may be manifestly excessive. Now, you might be forgiven for thinking that a request will be manifestly excessive where the individual is requesting a large amount of data and it would be very burdensome to deal with it. But that isn't actually what it means according to the ICO's guidance. It means a request that repeats the substance of a previous request where a reasonable interval hasn't elapsed, or a request that overlaps with other requests. So it's really focusing on whether it's a repetitive request rather than the amount of information that's being requested. The correct approach, if someone makes a request that appears to be very large and burdensome, is to deal with the request in a reasonable and proportionate way. So conduct a reasonable and proportionate search, not to say that you won't deal with it altogether. So a repeat request won't be excessive unless where a reasonable amount of time has passed since the last request. So you'll have to think about, for example, the nature of the data on whether it's likely to have changed in that time to decide whether or not a reasonable interval has passed. If you do decide that you are going to charge a fee instead of refusing to comply with the request altogether, then you should notify the requester of that, explain why, and you don't need to respond to the request, and your time limit for doing so won't start until you've received that fee. So overall, there is a difficult judgment call to make if you're going to rely on these, on the manifestly excessive or unfounded reasons for refusing to comply, because the onus is on you to prove it, and if you get it wrong, there are potentially large penalties. So I think most companies tend to err on the side of caution unless it's really, really obvious that it is either an unfounded or excessive request. So on the next slide, we'll just look at what you must do if you refuse to comply. So you must inform the individual about, firstly, the reasons why you've not complied with their request. Tell them about the right to complain to the Information Commissioner or another supervisory authority, and tell them about their ability to enforce this right through the courts. So I'll now pass over to my colleague Joe to discuss how extensive the search for data has to be.
Thank you very much, Mark. Good morning, everyone. I've just seen a question pop up. Can a request for information to be provided to an employee be extended beyond the current timetable due to the COVID pandemic? We do cover off the penalties in relation to a failure to respond to a DSAR a little bit later. What the ICO have said on their website and on their guidance is they can't physically change the regulations and the time periods that are enshrined in those regulations, but they are mindful of the difficulties that organisations are having at the moment in responding to DSARs. So they do take that into account when they're assessing what they should do when they receive a complaint about a failure to respond within the appropriate time period. And don't forget, you can ask for a 2-month extension in any event, and that might be a reason for doing so. Just thought I'd answer that one quickly. So yes, how extensive does our search for documents have to be? Dealing with DSARs can be very demanding and time consuming. We know that some organisations even have dedicated personnel to conduct the searches and respond to the requests. And in an employment context, it's even more complex because it's likely that material about an employee might be held in all sorts of different places, perhaps in an unstructured way. And when you do find the information, it can often refer to other colleagues, and then you've got that extra consideration about whether that information gets disclosed or not. A good starting point for employers is the Information Commissioner's Office guidance itself. Mark's already referred to it earlier. If there's one thing I would say is that the ICO guidance that's been developed is really clear, well thought through, and it's very useful. The general rule is that employers are expected to make genuine and reasonable efforts to find and retrieve the requested information. And then that's even if it's held electronically or as a hard copy, even if it's in archived or backed up electronic files, and potentially even if it's in email deleted folders. One of the things, however, that the guidance does say is if that data in the email deleted folders has been deleted with a view to permanently removing it, even if it's possible to reinstate it, the ICO will not expect you to do so. We know now, don't we, that there's lots of different ways in which IT experts can retrieve deleted data, but that if it's intended to have been permanently deleted, then the ICO won't expect you to look beyond that. And obviously, they expect you to look even if it's stored in different locations, provided, of course, that you remain the data controller of that data. What we know from a lot of our clients is that they might have a centrally held electronic HR file about employees, but they might also have other files that are retained by the line manager or the supervisor. Searchers are not expected to be unreasonable or disproportionate to the importance of providing the access to that information. And the burden is on the employer to show that any search is unreasonable or disproportionate. So let's have a look at the example that is on the next slide. This is an example from the Information Commissioner Office's website. An employee makes a DSAR for all the information that you hold about them. So it's a catch-all. I want everything that you hold about me. During your search for their personal data, you find 2,000 emails that the employee is copied into as a recipient. So other than their name and their email address, the content of those emails does not relate to the employee at all or contain any other employee personal data. So what does the ICO say? What the ICO says is you don't have to provide the employee with a copy of each of those 2,000 emails. The only personal data that is in those emails is their name and their email address. And it's completely sufficient for you to say to that person in the response, we have found 2,000 emails which contain your name and your email address and nothing else. There is no other personal data contained in those emails, so I am not going to share those with you. So provided you give an explanation as to why this is the only, that's the only information that they're entitled to, and explain any supplemental information concerning processing or how long you're going to keep those emails for, then you've done all that you should. And don't forget, the principal purpose is to provide the information that has been requested. And how that is done will, of course, depend on what the employee has requested and how you retain the information. So one way of ensuring that the search is confined to what the employee wants is to make sure you are clear about the request that they have made. So what will be reasonable will depend upon what has been asked for, and like I say, how the organisation has sorted all of the information. So be clear about what the request is so that you know what you have to search for. And then moving on to the next slide. Should we disclose information that refers to other people? At the beginning of this, I indicated that some of the complexities in a DSAR in an employment context is that often we find information that refers to a third party. That third party could be, for example, an organisation that's provided a reference for you in confidence, or some details about an employee who's made a complaint about the requester, the person that's made the request for the DSAR. So there is an exemption in the Data Protection Act 2018 that says you don't have to comply with a DSAR if doing so means disclosing information which identifies another individual, except where that individual has consented, or it's reasonable to comply with the request without the individual's consent. So although sometimes you may be able to disclose information relating to a third party, you need to decide whether it's appropriate to do so in each case. And that decision involves a balancing act, the balancing of the data subject's right of access to that information against the other individual's rights relating to their own personal data. If the other person consents to you disclosing the information about them, it is likely to be unreasonable not to do so. However, if there is no such consent, you must still decide whether to disclose the information anyway. I'll talk about this a little bit more later. Moving on to the next slide. In practice, the clearest basis for justifying the disclosure of third-party information in the response to a DSAR is that that third party has given their consent. So it's therefore good practice where possible to ask the relevant third party for their consent to the disclosure of their personal data. However, you're not obliged to ask for consent. Indeed, in some circumstances, it may not be appropriate for you to do so. For example, you don't have the contact details of the third party in question, or it would potentially disclose personal data of the requester to the third party that they weren't already aware of, or it would be inappropriate for the third party to even know that the requester has made a DSAR. In practice, it may sometimes be difficult to get third party consent. They might refuse, for example, or they may, as I've said previously, be difficult to find. If so, you must consider whether it is reasonable to disclose the information about the other individual anyway. So moving on to the next slide. In giving consideration to whether or not it's reasonable for you to disclose the information about the third party, the Data Protection Act 2018 says that you must take into account all the relevant circumstances. That includes the type of information that would need to be disclosed, the duty of confidentiality owed to the third party, any steps taken by you to try and get the third party's consent, whether the third party individual is capable of giving that consent, and the stated reason for the refusal of consent by the third party individual. This is a non-exhaustive list, and ultimately it is for you to make a decision, taking these factors into account. There was an interesting case on this point, and it was B versus the General Medical Council. And the Court of Appeal considered this balancing act, taking into account all those factors. In this particular case, a doctor objected to the production of his report when a patient sought to obtain it from the General Medical Council through a subject access request. The initial High Court proceedings decided that the GMC had been wrong to provide the patient with access to the report, and that it had not been given enough consideration to the doctor's privacy rights. So if you remember, it's a balancing act between the right of the individual to have access to their data and the privacy and confidentiality of the person who's the third party. The Court of Appeal actually overturned the High Court decision, and it held that the GMC had been entitled to reach the conclusion it had. In this instance, the Court of Appeal said the High Court had basically imposed its own views instead of looking at the reason that the GMC had given. The Court of Appeal said several things. Data controllers should be afforded a wide margin of appreciation when reaching evaluative judgments between privacy rights and other interests. There is no rebuttable presumption that the objector's view should prevail. So there's no obvious priority between the interests of the person making the data subject access request and the doctor in this instance. The fact that the requester might be seeking the information with a view to litigation should not interfere with the controller's assessment, and a controller might consider whether to disclose the information on the proviso that there are assurances or binding undertakings that the information should not be disseminated wider. So that's just an interesting case when looking at this balancing act. So Mark, back to you to respond to a couple more interesting questions.
Thanks, Jo. Just to say, by the way, I can see a few questions coming through. We will try to answer some of those questions towards the end of the session. Hopefully we'll have a few minutes to do so then. So now I'm going to look at what data are exempt and so don't need to be disclosed. So there are several exemptions in the legislation that allow you to withhold data for certain reasons. The first one is where legal professional privilege applies. So, for example, if you send a communication to your solicitor, if you would send a communication to me asking for some legal advice, you wouldn't need to disclose that as part of a subject access request because it would be protected by privilege. Secondly, any purely personal or household activity data. So, for example, if there are messages to friends and family that have nothing to do with work, or pictures of someone's friends or family for purely personal reasons, then those would fall outside the scope of a subject access request. Any references that are given for employment, training or educational purposes don't need to be included in the response. Then there's a couple of exemptions for that relate to the management of the business. So the first one is data that's processed for management forecasting or planning if disclosure would prejudice the business activities. So an example of that would be if you were planning a staff redundancy program, it would be prejudicial to the business to disclose that to someone in a subject access request before it's been announced to the workforce. So in that situation, you would be able to withhold that data. Also, any records of intentions in negotiations between you and the employee, if disclosure would prejudice the negotiations. So of course, if there was an email between managers talking about the maximum that you would offer an employee in a settlement negotiation, it would obviously prejudice the negotiation if you were to provide that information in a subject access request. So in that situation, you wouldn't need to disclose it. And there are some other exemptions that I haven't gone into here because they're less likely to apply. They're fairly niche, but you can see those in the final point there on the slide. So next, on the next slide, we will look at what information needs to be given in a subject access response. So of course, the first thing is you have to provide a copy of the data. Now, the requirement is to provide a copy of the data and not a copy of a specific document. So that means that although you can choose if you want to simply provide the document, you actually don't need to. You could extract the relevant data into a spreadsheet. And I have seen some companies that do that. I suspect in most cases, employees that are making DSARs actually want the documents rather than their personal data. So it may well frustrate them to receive it in a spreadsheet, for example, but you can do that if you want. The reality is, though, most companies don't want to spend the time of doing that exercise of extracting it, so they just provide the documents. You have to provide the information in an accessible, concise and intelligible format. The information has to be disclosed securely, and where personal data is repeated in several places, you only need to provide it once. And as Joe was referring to earlier, where you've got a large quantity of largely repetitive data, such as the email example she gave earlier, you could just summarize the data fairly and in reasonable detail, as long, of course, as you're not taking that approach in order to hide any information that you prefer not to disclose. And just make sure that when you provide copies of the data, you don't inadvertently disclose personal data about others without going through the mental gymnastics that Joe was referring to earlier, considering whether you ought to do so. So it's often also forgotten that as well as providing the data itself, you also have to provide several pieces of information to the requester alongside the data. And that information is set out on the slide there. So it's the purpose of the processing. Now there you should refer to any privacy notice that you've got and make sure that the purpose that you're giving is consistent with the purpose that's said in your notice. You have to give the categories of data, which often will be emails or other documents that are processed in the course of employment, the recipients or categories of recipients. Now, you don't need to specify particular individuals that the data has been sent to. That would be too onerous, particularly when you're dealing with large amounts of emails. You can just summarize or categorize that, such as, other employees, for example. You have to give information on the source of the data if it wasn't obtained directly from the employee, your retention periods, and again, you should make sure that that's consistent with any information in a retention policy. Now, you have to state also whether automated decision making was used and the details of any logic involved and the significance for employees. Now, most of you probably won't be conducting automated decision making, although you might do in recruitment. For example, if you have a system that automatically filters CVs, then that would be a form of automated decision making, and you would need to give some information on that. You also need to provide details of the individual's rights, so the rights to rectify, erase, restrict, and object. And where data is transferred to a third country, you have to provide some information about the safeguards that are in place to protect that data. So, for example, there are certain clauses that you can put into commercial contracts that provide some safeguards about how the organisation that may be in another country will deal with the data. And finally, you have to again tell them about the right to complain to the ICO. So on the next slide, Joe will now look at some of the consequences of breaching the legislation.
Thank you very much, Mark. So as Mark mentioned at the end you have to put in your response an employee's right to complain to the ICO. So anyone has a right to make a complaint to the ICO about any infringement of the data protection legislation in relation to their personal data. So, for example, if the controller fails to comply with a DSAR. In appropriate cases, the ICO may take action against the controller or processor if they fail to comply with the data protection legislation. And you, as the employer or the controller or the processor, can get issued with a warning, a reprimand, an enforcement notice, or a penalty notice. The ICO use these in circumstances where they want to explain where an employee might have got something wrong. I've seen them where the ICO have said the employer needs to take some certain steps with the person who's made the data subject access request, and provided they take those steps, there's no further action. So they tend to look at it from a very practical point of view. They try to respond to any complaints by seeking to remedy or rectify any particular issue, which is always good. And moving on to the next slide. Also, if you fail to comply with a DSAR, the requester, the data subject access requester, may apply for a court order requiring you to comply with their request. It's a matter for the court to decide in each particular case whether to make such an order, and they do tend to be factor specific. The court can make an order for the purposes of securing compliance in accordance with the data protection provisions of 2018 Act. It's similar to the scope of the data protection provisions in the 1998 Act. So it's likely that some of the previous case law will apply. The power can only be exercised if there is an infringement of rights. The starting point for the exercise of the discretion of the court is that there is a breach of the duty. And in exercising the discretion, the court must have regard to the general principle of proportionality, which I've talked about previously. The court will seek a fair balance between the rights of the data subject and the interests of you as the processor or controller. So factors to be taken into account depend upon the particular circumstances, but they might include things like the nature and gravity of the breach, whether there is a more appropriate route to obtaining the information, such as ordinary disclosure in litigation, whether the real aim is to see documents rather than personal data, the reason that the employee is making the subject access request, and the potential benefit of the data subject, and whether he or she legitimately wishes to check the accuracy of the personal data. Can an individual be awarded compensation? If an individual suffers damage or distress because you've infringed their data protection rights, including a failure to comply with a DSAR, then they are entitled to claim compensation from you. Only the courts can enforce their right to compensation. However, an employee may seek to settle a claim with you directly first before issuing court proceedings in the normal way. And you'll not be liable to pay compensation if you can prove that you're not responsible in any way for the event that gave rise to the damage to the individual employee. So there's got to be a causal link. Moving to the next slide. It is a criminal offence to alter, deface, block, erase, destroy or conceal information with the intention of preventing disclosure of all or part of that information to the person making the DSAR. You can defend this offence if you can prove that that alteration, defacing, blocking, erasure or destruction or concealment would have happened regardless of whether the individual made the DSAR. Or you acted in the reasonable belief that the person making the DSAR was not entitled to receive the information requested. And don't forget that UK GDPR and DPA of 2018 set a maximum fine of 17.5 million or 4% of your annual global turnover, whichever is the greater, for any infringements of the Data Protection Act, including any infringement under the DSAR regulations. So maybe, Mark, back to you. Are there any questions coming through that need answering?
Yeah, thanks, Joe. We'll just look at some of the questions that have come through. One of them, can we refuse to comply if it's being used to get disclosure for litigation? And the simple answer to that one is no, unless there's another reason to believe the request is manifestly unfounded. That alone, I don't think will be enough not to comply. Just because it might be useful in litigation. See which other ones there are. One for you, perhaps, Joe. Do we need to search text messages on company mobile phones?
Oh, thank you, Mark. Yes, that's an interesting one. There is a difference between a mobile phone that is provided by the company and one that is a personal mobile phone, which is just simply used for business purposes. A personal mobile phone obviously isn't in your control. It's in the control of the individual personally. So if somebody chooses to use their own personal mobile phone for communicating on work matters, then you don't have control over that data. You're not obliged to search it and you're not obliged to disclose it. But there would be a difference in relation to a company mobile phone, because that is your property as the employer. There are methods under which you can easily search those text messages. If it is a method that is used in organisations to share company information, then there would be an expectation that you would conduct a search. The same in relation to WhatsApp messaging. I know that a lot of our clients have have work sort of WhatsApp messaging, and the same would apply there. Sometimes you have to go back to the mobile provider, I think, to get hold of that sort of information, but there would be an expectation that you at least try and see if you can obtain that information. On the same lines, there was another question that came through. I gave you an example of searching for emails and seeing 2,000 emails where the data subject is merely the recipient. The question that was asked was, if the data subject asks for a search in a limited time frame and you still get those 2,000 emails which contain only the name and email address alone, does the same answer apply? And the answer is yes. If it's 2,000 emails and the only bit of personal data is their name and their email address, all you need to say in your response is, I've got 2,000 emails with your name and your email address and no other personal data, and so I'm not going to share those with you. Back to you, Mark. Any other questions?
Yeah, there's got time for a couple more. A couple of people have asked about how you should provide the data, whether to provide it in hard copy or email format. So the legislation says you have to provide the data in a written format, but it also says that where an employee makes a request by electronic means, then you should generally respond in the same way. So you should respond by electronic means. I do know that the ICO's guidance says that it's good practice to ask the requester what their preferred method to receive the data is. So I would suggest asking them how they want to receive it, and then, unless there's a good reason not to, complying with that request. I just see if there's perhaps got time for one or two more. If a DSAR is not clear at the point of request, is it reasonable if we request that the employee completes a document asking for a clear indication of what specifically the DSAR is? Yes, so where you're processing a large amount of data, then there is a recital in the GDPR that says you can ask the requester to clarify what they want, but the aim shouldn't be to get them to narrow the scope of the request. It's to find out what they want, and you shouldn't seek clarification on a blanket basis. So you should only do so where it's genuinely required, and you process a large amount of information. It's just worth bearing in mind that employers can't, as they can't be forced to narrow the scope of the request, but you can certainly seek clarification where you need it. Right, I'll just pick one more question. Just have a look. Do we need to postpone a disciplinary if someone makes a DSAR? I think that that's probably more a question about the fairness of the disciplinary than data protection law. I think if someone is making a specific DSAR request, if they've identified specific documents that they think are missing from the disciplinary process, and they make a DSAR to make sure that you provide those documents, then yes, I think you should be dealing with that before you progress the disciplinary, because if you don't include relevant documents, then it may be an unfair process. On the other hand, if someone's making a purely speculative DSAR, where you've asked them what data they want, whether there's anything specific, and they can't identify anything specific that's relevant to the disciplinary, then I think you would be in a stronger position to say that you're not going to delay the disciplinary process to deal with that request. I think the risk, though, for your organisation is if you proceed with the disciplinary first without and then deal with the DSAR second, if something comes out in the DSAR which actually was relevant to the disciplinary and which should have been included, then it may make the disciplinary process unfair. So you have to be fairly confident, I would say, that there's nothing in the DSAR that's relevant to the disciplinary in order to take that approach. Right, I think that's all we've got time for today, unfortunately. Thank you very much for attending. If you want to discuss any of the issues that we've talked about, our contact details are on the slide. We're always happy to have a chat about any of these issues. We will be sending a copy of the slides out, and hopefully we'll see you at our next webinar, which is tomorrow at the same time, where we're going to be talking about a further more case law, another case law update. Some of the questions going to be quite interesting. Can one employee transfer to multiple transferees under TUPE? Can a dismissal for some other substantial reason without any procedure be fair? And when might you be liable to pay an employee's wages whilst their unfair dismissal claim is waiting to be heard, among some other cases? So please do join us for that one. And thank you very much for attending today.
Thank you, everyone.